I totally freaking fell asleep and forgot about this. I don't know who Robert Zadar is. Anyways, though, this is not about that. So we're gonna. I wish I could remove the comment. Yeah, you know what? I don't like. Anyways, I'm sure you guys can see with the thumbnail that I didn't know this, and maybe I just haven't been keeping up enough with all the information out there. But apparently Ann Taylor, I'm assuming this is just as my opinion as far as this next comment goes. I'm assuming Ann Taylor was like assigned counsel for Xana Kernodle's mom. I believe her name's Carrie Kernodle. I'm assuming Ann Taylor was her counsel, like the court-appointed attorney at one point. From my understanding from the documents, that Ann Taylor resigned basically from being Xana Kernodle's mom's attorney so that she could take on Kohberger as his counsel. And so from my understanding, is the Goncalves's family attorney is now notifying the court about that conflict of interest, because 100% that would be conflict of interest. An attorney that was representing one of the victims' mothers for it was a completely separate case, obviously, but still, that's definitely conflict of interest to go from working for one of the victim's parents to now working for the accused murderer of the daughter of her ex-client. It's crazy. It's way crazy. Crazy. But yeah, I don't know if I'm just now like learning this and other people know this, or if it's just something that I just realized in the paperwork. Yeah. I can't wait till I get my other computer though, because then I can read so I can read it. I wonder if I can pull it up while I'm on here. I don't think I can. Yeah, when I get my computer, I'll be able to do that kind of stuff. But I that's fascinating, which would make sense because I saw other paperwork where one party was requesting co-counsel. I'm not sure which party. Matter of fact, I wonder if I have my other phone on me. I do. Yeah, so I'm not sure if you guys heard what I was saying, but I just found, well, last night, this morning, I found some paperwork filed in the Kohberger case, the Idaho 4. The Ann Taylor, Kohberger's attorney, used to represent Xana Kernodle's mom, which I'm assuming to have been like court-appointed attorney for some of her other charges. But it says in the documents that and Taylor resigned as counsel basically for Xana Kanoto's mom to take on Brian Kohberger as a client, and that is 100% conflict of interest. And it is the Goncalves's attorney that is bringing this attention to the courts. There's quite a bit going on right now behind the scenes, and it's crazy. Dang it. My other phone's dead. But as you can see in the thumbnail, that is the excerpt from one of the request to seal documents. I'm gonna go grab, hold on. Yeah, once I get my computer, I'll better do this a whole lot better. I'm gonna read it. I just have to pull up the documents on the site. Hey, the loser. Yeah, I'm pulling up the documents right now. I just have to go to the website because I have them on my phone right now. So, and I'm clearly on my phone. But once I get my computer, it will be better. Okay. Let's see. It was the which one was it? It was I'm pulling up the document, sorry. There's like 30 free quarter deal. Why is it telling me to do all this, babe? Set your shit up. Come on. Okay, just once. What do I do? Oh my goodness, this is so fucking annoying. Like hella annoying. That's gonna piss me off. Okay. Great, not that one. I know, I don't know, because loser, I don't have the right setup and stuff for that right now. I can't. Let's go shopping then. Okay, which one was it? Oh, that's right. So it was a memorandum to unseal court record. So from my understanding is that there was a hearing that was done that should have included the Goncalves' attorney and also any other party's attorney that's involved in the case. But apparently it was done without his knowledge. So I'm just going to read it. It says, I, Shannon Gray, am an attorney licensed in the state of Idaho. I represent victim Kaylee Goncalves' family in the above referenced matter. I make this memorandum in support of the motion to unseal the court record regarding conflict issues of the defense counsel. The court held a hearing regarding conflict issues of defense counsel Ann Taylor on January 21st, 2023. The parties present were defense counsel and Ashley Jennings representing the Latah County Prosecutor's Office. I am not aware of any other counsel that was present at the hearing. I am also not aware that anyone other than the parties mentioned above were even notified of the hearing on this matter. The Goncalves' family and I only became aware that there was a hearing on this matter from a meeting with the Latah County Prosecutor's Office and investigators on February 8th, 2023, or we would have never known such hearing took place. And this is the legal authority. Idaho Court Administrative Rule 32 governs the release, exemption from release, and limitations upon release of judicial records. Specifically, ICAR 32 outlines the procedure for sealing court records. In ruling on whether specific records should be disclosed, redacted, or sealed by order of the court shall determine and make a finding of fact as to whether the interest in privacy or public disclosure predominates. If the court redacts or seals records to protect predominating privacy interests, it must fashion the least restrictive exception from disclosure consistent with privacy interests. Before a court may enter an order redacting or sealing records, it must also make one or more of the following determinations in writing. Now, this just gives the criteria according to that statute of how the court could or should, make their decision. And then this is stating an actual court hearing. Okay, so it says State versus Allen, 156 Idaho 332.336, 325 P, and then there's 3D, 673, and then 67, and then it says court appearance 2014. That rule provides the public has a right to examine and copy the judicial department's declarations of law and copy the record. It says Idaho Code Section 74-101 sequence memorializes Idaho's Public Records Act in determining whether general public, unquote, and, quote, whether public access plays a significant positive role in the functioning of the particular process in question, unquote. Okay. Now this is the argument. Oh my goodness. Okay. The argument. Since the record has been sealed regarding the conflict issues regarding defense counsel Ann Taylor on this matter, and the fact that the Latah County Prosecutor's Office did not offer any objections or evidence at the time of the hearing, we will presume there is minimal record of findings and conclusions. It is also my understanding that there were no witnesses called during the hearing and no other outside testimony was given to the court other than that of defense counsel Ann Taylor. In determining whether to seal the record of the hearing on the conflict issues of defense counsel Ann Taylor, the court would have to analyze and apply ICAR 32I and public policy case law. Conflict issues in this case would involve Ms. Taylor's ability to represent Mr. Kohberger after previously representing Kara Kernodle, the mother of one of the victims in the case, Xanas Kernodle, as well as any other actual or potential conflicts with any other clients. In addition, the court would have had to address any issues regarding why Ms. Taylor withdrew from Kara Kernodle's representation as a current client in order to take on Mr. Kohberger's case. That would include if there has been a waiver filed by Kara Kernodle and or possibly eliciting testimony from Kara Kernodle to determine the extent of any contact and information related to Ms. Taylor during the representation. Additionally, the court should have considered the potential for a conflict to arise at different stages of the criminal proceedings based on Ms. Taylor's prior representation of any witnesses or parties involved in this matter. Upon gathering this information, the court should have first determined whether the sealing the record of the conflict hearing is consistent with openness and public policy. Secondly, the court should have determined whether sealing the record of the conflict hearing is consistent with the type of hearing being historically open to the press and general public. Finally, the court would need to have applied ICAR 32I and made a finding of fact regarding the applicable issue and fashioned the least restrictive exception consistent with privacy interests. Taking into consideration the information the court reviewed in this case, which was merely defense counsel and Taylor's testimony to the court, the scope of the information obtained by the court from Ms. Taylor, and the lack of any findings on this matter, the court must unseal the court record regarding the conflict issues with defense counsel. In applying the above considerations, it is not common to seal records regarding conflict issues of attorneys. At this stage of the criminal proceeding, conflict issues should be open to the public. This avoids any actual or potential conflicts the court may not be aware of and helps ensure any actual or potential conflicts may be avoided. By opening the record to the public, the court can fully analyze all conflicts, not just those recognized by defense counsel. The number of witnesses in the scope of this case is massive, and the possibility of other conflicts regarding defense counsel should be thoroughly investigated. I cannot see any fact pattern applying the above determinations that would justify the court sealing the records of the conflict matter in this case. It appears the only testimony given at the hearing was Ms. Taylor's. Additionally, the Latah County Prosecutor's Office failed to do any due diligence prior to the hearing regarding any conflicts and failed to inquire or object at the time of the hearing to clarify or identify any actual or potential conflict. The proper remedy for the court, if they believed that protected information had been provided, would have been to redact that information and then provide the full record to the public. Therefore, on behalf of my clients, the Goncalves' family, we would request that the court unseal the court record regarding the conflict issues of defense counsel in this matter. I'm just saying big words. No, so this attorney does not believe that there was enough information or enough personal information to have sealed the conflict hearing. So there was a conflict of interest hearing brought up against the defense counsel, which is Ann Taylor. Ann Taylor is Kohberger's attorney. Ann Taylor resigned her being a representation for Kara Kernodle, which is Xana Kernodle's mom, to take on being the legal counsel for Kohberger. So that is in its own right conflict of interest. However, what I was reading was about how usually these kind of hearings are not redacted or sealed, and that they're, given the fact that it was only Ann Taylor's testimony that was utilized in that hearing, there was not any information that would risk any other potential witnesses, safety, for them to have any justification for sealing that hearing. So the attorney is requesting to have the paperwork and the documents filed on that hearing to be unsealed. I'm sorry that you people don't understand what the fuck I'm reading. Did I dumb it down for you? And there has not been a response yet for what I just read. But there was. Ooh, all right. So it looks like there was a response. Looks like there was a response. Wow. Be it known that the following proceedings were had to wit. Court noted that this is the motion to redact and unseal the documents that I was about the court hearing I was just reading about. That's funny. So it says, be it known that following proceedings were had to wit. Court noted the presence of counsel and the defendant and stated that the defendant is still in custody. Court noted that all parties were appearing via Zoom. Court stated that this is the time set for the status conference. Court stated that this is a sealed recording of the proceeding and the minutes will be sealed in the court file. Court stated that the purpose of this hearing is to ensure the defendant is fully advised of his right to counsel and any potential conflict Ms. Taylor may have. Court further stated that the court recently met with Ms. Jennings and Ms. Taylor and it was determined that it would be prudent to have this hearing. Court stated that Ms. Taylor is the appointed public defender for Kootenai County, and the Miss Taylor's name is on nearly all letterhead for the Kootenai County Public Defender's Office, whether she is the acting attorney or not. Court explained to the defendant that a conflict of interest can arise if counsel currently or previously represented an individual, or if there is some other conflict such that they would need to withdraw. Court stated that this court generally leaves the issue of conflict and the decision, if it is necessary to withdraw, to each attorney on a case-by-case basis and to allow counsel time to discuss this decision with the individual they are representing. Court stated that based upon discussion with counsel this morning, it is the court's understanding that the defendant is in agreement with Ms. Taylor's continuing to represent him, and further stated that it is the court's understanding that Ms. Taylor does not believe there is a conflict. The defendant stated that this is correct. 12:51 p.m., Ms. Taylor stated that her name appears on every document in the public defender's office, but below her name is the individual who actually represents the named individual in the case. Ms. Taylor stated the specific issue with the media has brought attention to our two cases involving Xana Kernodle's mother, Ms. Kernodle. Ms. Taylor stated that there was an open felony case that she was not assigned to, and the case has since been conflicted out. Ms. Taylor further stated that there was a 2017 misdemeanor case which was sentenced and her office was waiting to withdraw from. Ms. Taylor stated that the public defender who represented Ms. Kernodle in that matter was, and then it redacted that information, who left the public defender's office in September or October. Ms. Taylor stated that her practice is to transfer all cases that are pending withdrawal or have a bench warrant issued to her. Ms. Taylor stated that the 2017 case was assigned to her on October 20th, and from October 20th until the date she withdrew, Ms. Taylor stated that she had no contact or relationship with Ms. Kernodle and has not met her or provided any legal advice. Ms. Taylor stated that most of what the media is reporting on regarding the Kootenai County cases is untrue. Ms. Taylor stated that she has spoken with Bill Thompson and Ashley Jennings and explained the above situation to them. Ms. Taylor stated that she has spoken with redacted at the ISB Bar Counsel's office, who conferred with redacted, and all three do not believe that there is a conflict, so long as the defendant is comfortable with her remaining on as counsel. Ms. Taylor stated that there is no other person that she is connected to in this case, and stated that Mr. Kohberger is the only individual in this case to whom she owes a duty of advocacy and loyalty. Wow.
12:54 p.m. Upon inquiry from the court, Ms. Jennings stated that this is her understanding as well. Court questioned the defendant. The defendant stated that given the information he has heard and the conversations he has had with Ms. Taylor, he feels comfortable proceeding with her as counsel. 12:55 p.m. Court advised the defendant of his right to have an attorney, and if he believes there is a conflict, the court can find and appoint different counsel. The defendant stated that he understood. Court questioned the defendant. The defendant stated that it is his wish to proceed with Ms. Taylor as counsel. 12:56 p.m. Court stated that there is a lot of speculation surrounding this case and has spoken with the attorneys regarding staying focused on the facts. Court appreciates this issue being brought to the court's attention and stated that this information appropriately covers any concerns. Court recessed at 1:05. Bye, the loser. I don't know how I feel about that. Motion to appoint co-counsel, though, so they obviously are bringing somebody else in. Ow. They are bringing in an attorney that is experienced in death penalty cases. So looks like they're going after the death penalty on him. I don't think we've heard that before yet. But comes now Ann C. Taylor, Kootenai County Public Defender and attorney for the above-named defendant, moves the court to appoint an additional death-qualified co-counsel in the above-entitled matter. This motion is made pursuant to the 5th, 6th, 8th, and 14th Amendments to the Idaho and United States Constitution. Rule 44.3 of the Idaho Criminal Rules, IDAPA 61.01.08, and the American Bar Association guidelines for the appointment and performance of counsel in death penalty cases. J.W. Logsdon, Chief Deputy Public Defender, bar number 8759. So, interesting. Looks like they'll be going after the death penalty. Did you guys know that Idaho actually performed a death sentence? They carried out a death sentence on an individual on the 23rd of March of 2023, just a few days ago. They carried it out. Yeah, I'm not too much into that Gwyneth Paltrow case. I don't know. I just don't know. That really didn't pique my interest. What do you think? Do you think that she is responsible? I mean, that she should have to pay anything? Because I don't know much about it. Honestly. I only caught like one day of it. Excuse me. Now there's a bunch of orders to seal, like Wells Fargo, Umpqua Bank, Financial Credit Union, Numerica Credit Union, Idaho Department of Labor, Idaho Central Credit Union, Elan Financial Services, eBay, Dropbox, Discover Bank, the Coeur d'Alene, I don't know how to pronounce that, Police Department, Forensic Lab, Charter Communications, Blue Ridge Knives, Banner Band, Bank of America, AT&T, Apple, American Express, Amazon. Let's see, where else is there? Yeah, eBay. And then there's the Wells Fargo orders were okay. And then there's more order to seal: Verizon Wireless, Washington State University, DoorDash, Extreme Networks, Google, Inland Cellular, K-Bar Knives, Match Group LLC, that's quite a few of those. And then Meta platforms, there's like about 5 or 6 of those. Moscow Police Department Forensic Lab, PayPal, Venmo, Reddit, Snap, T-Mobile, Quabank, United Parcel Service, Verizon Wireless, Walmart, Yahoo, Yik Yak Inc., Google, and Google. Those are all separate order to seal. So like all the I'm assuming the affidavits or everything they request, all the information they requested from all those companies, they requested to seal so that the public could not gain access to that information. Let's see what the case summary shows. Because sometimes I found that there's stuff missing on there that it shows on the case summary list. I'm just going through this to check it real quick. And the preliminary hearing is still on, right? I'm now been catching up on some. The preliminary hearing is still on 6/26, but they're bringing in co-counsel that is experienced. If I read that correctly, is experienced in death penalty cases. So I'm assuming they're going after him for the death penalty. That's my understanding. Also, I spoke to the municipal court as well as the prosecuting attorney's office today, and there is a warrant out for Alexandra's arrest. She did lie when she stated that she spoke to them and she quashed the warrant, because as of today, there was no court dates for her to appear at. They went straight to an arrest warrant. So she has an arrest warrant out for her arrest. 100%. But I just forgot. I fell asleep way early this morning, and I forgot that I had set up the live because I was just gonna stay awake. But clearly, I did not do that. So I just wanted to go live and finish this. So I'm gonna end here actually. I might go later, but tomorrow something important, and so I'm gonna finish getting stuff ready for that. Yeah, so I appreciate those of you that did stick around. All 6 of you. Yeah, so anyways, so thank you. Bye.